20 to 30 minutes of Q&A. For remote attendees, please type any questions for the speakers into the Q&A function on Zoom, and a moderator will read them out on your behalf. Anything else? We'll take a brief break between each session just to stretch the legs and air out the mind, and then a longer coffee break around 3:50 to 4:10, depending on the timing. For those in person and in need of more regular caffeination, there is coffee outside in the lobby already, so feel free to dip out whenever you need. Before I wrap up, from this too long introduction, I want to extend a thank you to our principal investigators at the Center on Forced Displacement, Carrie Preston, Mohammed Zaman, Marina Lazedek, and Nora Laurie of the Patti School on Global Studies, as well as to all the members of the CFD who helped bring this series and this particular event into existence. And a very special thank you to Chrissy Lucchini, without whom this would not be possible. She saves the day pretty much every day. Okay, so without further ado, I'm very pleased to be introducing our first speaker today, joining us from England, who is David Owen, who is Professor of Social and Political Philosophy at the University of Southampton, and who will be giving a talk today titled Border Externalization and the Paradoxes of Humanitarianism. Is that correct? Take it away, David.
Thanks, and thanks very much for inviting me. Pleasure to kind of be here. Right, so because I'm first up, I thought I would at least start by trying to kind of say something about, why border externalization, why this particular governmental practice, what's its rationality, and what grounds its claim to legitimacy. So if before I bang on, I remember to share my screen, I will be able to show you some of this. Cool. Hopefully that has worked. So let's start with David Fitzgerald from his lovely book, Refuge Beyond Reach, use of the medieval fortress as giving us vocabulary for forms of border externalization or techniques of remote control. So Fitzgerald just identifies a range: domes, caging, buffering, moats, barbicans. These are all different, as it were, techniques that can be used to, as it prevent people reaching the territory of the state. Now, what I want to do, the questions I want to address is, as I said, why border externalization? What's the rationality of it? What grounds its claims to legitimacy, which shift after 1951 and shift again after 1967? What normative and institutional resources does this practice draw on? And what's required to address it and the sources that generate it? So let me just quickly, and this is going to be pretty quick and sketchy, identify some background reasons. Firstly, reasons of the sovereign state as a political form. Secondly, logics of territoriality. Third, laws of refuge. And fourth, ethics of humanitarianism. And I'm going to sort of suggest to you that it's actually through the conjunction of all four of these that we find the rationality of border externalization emerge. So very quickly, reasons of the sovereign state as a political force. So there is, if you like, a dominant picture about states and state legitimacy as characterized by positive internal criteria. States look after their citizens, deliver their rights, particularly human rights, but also civic rights, and a negative external criterion. As long as states don't actively breach the human rights of other people, that's fine. That's the limit of their responsibility. And that picture of state legitimacy gives rise to a kind of way of thinking about the logic of the state in its relationships to outsiders that's nicely expressed by Matt Gibney. He says, look, above all else, the state is fundamentally an answer to the question of who's responsible to whom in the modern world. States are responsible to their own citizens. The survival of the state as an entity over time rests, moreover, on its ability to portray itself convincingly as an answer to such a question. As a consequence, the claims of outsiders are assessed by states, including liberal democratic ones, through a logic that depreciates the interests and need of outsiders, a logic that's extremely sensitive to the potential damage to its own authority involved in forcing its citizens to incur costs for the sake of strangers. So I kind of think the dominance of this kind of picture of the state and the state's, if you like, self-perception in terms of it, is the first kind of background source with which we need to be concerned. Second, logics of territoriality. Under the territorial principle of jurisdiction, states are responsible for all persons within the jurisdiction, so on its territory. That has a special issue, raises a special issue for democratic states to do with kind of naturalization. But conversely, if non-citizens are not on its territories, then the state's not responsible for them, except insofar as it has to, as it were, not actively breach their human rights. Okay, third source, laws of refuge. So if we think about refugee protection as a cooperation game, we run straight into the kind of standard collective action problem. If refugee protection is a global public good, then collective action problems arise. So we can see the Refugee Convention as a partial and inadequate response to this. The key norm is that of non-refoulement, and it gives rise, as Alex Betts has pointed out, to what we might call a north-south suasion game. Now, the current suboptimal outcome of that Alex Eleynikov and I expressed as follows. There's been an unholy grand bargain at the heart of the international refugee regime. States of the global south take the vast majority of refugees, insofar as states of the global north provide, albeit inadequate, financial support and don't press human rights concerns. We might note here that the proximity to refugee production, like refugee production itself, is typically a product of durable patterns of global domination and disadvantage that are part of the continuing afterlives of European imperialism. Consequently, for the most part, those states who produce are in close proximity to and bear the burdens of significant refugee flows of post-colonial states. I'm now going to just set that aside because Ayten will speak much better to it than I could. Okay, fourth element, ethics of humanitarianism. Almost immediately, the Refugee Convention was signed in 1951. It was subject to a kind of moral arbitrariness challenge. Surely people said, look, the differentiation of those whose lives are endangered by persecution and those whose lives are endangered by the breakdown of public order seems to lack moral grounding. So too does the differential treatment of those outside and inside the state in question, or whose lives are threatened by natural disasters rather than human ones. So humanitarianism immediately poses this challenge that, the terms of the Refugee Convention are just morally arbitrary. That gives rise to a moral solidarity claim. We ought to approach all these persons as having the same kind of claim on us, okay? And while the conditions they're in may affect how we can help them, insofar as we can, we should do so. And so we get, over the course of the last 60 years, something like a kind of shift or a kind of humanitarianization of the figure of the refugee, who rather than being a political subject of civic and human rights, becomes a humanitarian subject of needs, one whose minimal or basic human rights should be respected, subsistence, primary education, basic healthcare. But, who isn't, as the convention had it, immediately to be situated in a position between the most favored immigrant group and citizens, with the rights of some of the rights of citizens and some of the rights of the most favored immigrant group. At the same time, of course, this leads to a significant expansion of the potential subjects of protection. So take those four things together, and we can understand the rationality and legitimacy of border externalization seen from the state's point of view. Humanitarianism expands the category refugee and legitimates the idea that as long as refugees are provided with basic needs in a camp, say, and are safe and protected, that's sufficient. Non-refoulement as the core norm makes territorial presence the critical factor. Territoriality makes access to permanent residence or citizenship a function of presence. And states have an interest in controlling exposure to protection, to their exposure to protection responsibilities. So the combination of those things leads to border externalization as in principle a legitimate mechanism to avoid the potential damage to its own authority involved in its citizens being able to incur visible costs, the presence of refugees, for the sake of strangers. Much easier to get finance for protection elsewhere through the governmental books. So if we think about why states might, like this governmental technology of border externalization, and why they might think about it as a legitimate technology, then I think the combination of the character of the international refugee regime, the fact that territoriality is the principle of jurisdiction, and the spread of a kind of humanitarian conception of refugees have combined to push in this direction. Now, as David Fitzgerald points out, particular ways in which it has been developed relate to particular refugee crises. But I'm concerned in a sense that what makes the rationality appealing and apparently kind of legitimate, or at least having a claim to legitimacy from a state's point of view. So we can see border externalization and then as exploiting the limits of non-refoulement. So, as commented in relationship to the EU currently, the system as currently devised appears to imply that while pre-entry controls can operate extraterritorially, protection obligations arise only if potential beneficiaries present themselves at the physical borders of the EU, and that no distinction is necessary at the pre-border stage between refugees and other migrants. It seems to be understood that pre-entry controls can be conducted independently from their differential impact on protection seeker rights. So in this line, Heilbronn has argued, it's doubtful whether the principle of non-refoulement implies a general duty of states to organize their entry and immigration, visa and transport legislation in such a way that potential political refugees may use their right to seek and enjoy asylum effectively. He opines, a legal duty arises only when and insofar as a potential refugee has come within the scope of the territorial jurisdiction of the state. So what are the effects of this, as it were, rationality and practice for refugees? Well, as Serena Parekh nicely puts it in her recent book, No Refuge, refugees essentially are left with the following choice set. Typically, long-term residence in a refugee camp with very limited opportunities for shaping one's life. Precarious lives in urban or peri-urban settings with a potentially wider range of opportunities, but significant risks of exploitation, domination, and marginalization, or dangerous journeys to advantaged states. Some refugees, very unsurprisingly, take up the third option, that of dangerous journeys. Given the emergence of this travel market, that providers of border crossing services arise to meet demand. That's what one would expect. So the rise of the smuggling industry is then best seen as a response to the failure of the refugee protection regime to provide access to forms of protection in which refugees can coherently understand themselves as effective social and political agents, able to navigate their environment and shape the development of their lives without incurring unreasonable costs. So that's all the background stuff. Bitter ironies. So the effect of this development is not only that it increases the dangers of refugee journeys, given that the illegality of border crossing services means their supply is most likely to draw in providers already operating in zones of criminality. But also, and this is what I'm going to focus on for the remainder of my time, that this fact is in turn taken up and mobilized as a humanitarian reason for further intensification of border externalization policies and technologies of remote control. So this brings us to what we might call justificatory in humanitarianism. And here's a first example. So the Australian Prime Minister Tony Abbott in 2015, as part of his response to the UN rapporteur's charge that Australia's refugee policy was in breach of its international commitments, said the following: "The most humanitarian, the most decent, the most compassionate thing you can do is stop these boats, because hundreds, we think about 1,200 in fact, drowned at sea during the flourishing of the people smuggling trade under the former government." This rationale is one that's been embraced most recently by the EU in relationship to Mediterranean sea crossings and by the UK in relationship to boats crossing the Channel. Now, it would be easy, and perhaps not wrong, to dismiss this as simply cynical hypocrisy. But that response, while it may be okay as far as it goes, doesn't go very far. Instead, I want to kind of think about what is it about the language of humanitarianism that lends itself to this kind of justification. So I want to do this by drawing attention to the fact that humanitarian reason is situated within and involves the negotiation of a tension between two distinct justificatory poles, which we can gloss as follows. A commitment to the view that humanitarianism means acknowledging that the suffering of each and every person matters in and of itself, and a commitment to the view that humanitarianism means aiming at the reduction of overall suffering. So we might see the former as one that pictures the humanitarian ideal as a constraint on action, and the latter as a commitment that pictures the humanitarian ideal as a goal to which action is oriented. But this gives rise then to two different forms in which that tension can be mobilized to support border externalization policies. So here's the first form. Humanitarian government, operating under the picture of humanitarian ideal as constraint, all lives matter equally, may generate outcomes that are, in terms of the picture of the humanitarian ideal as a goal, bad. One way, overall suffering goes up. One way of negotiating this tension is to construct a distinction between naive and realistic modes of humanitarianism. So this makes available a form of argument in which certain kinds of humanitarian practices can be represented as self-defeating. So in the context of refugees, this takes the form of the argument that, for example, the operation of humanitarian search and rescue operations in the Mediterranean serves as a pull factor that increases the numbers of people who are willing to undertake the journey with all the suffering and risks of death that it involves, and hence is liable to increase overall suffering and deaths. I mean, that complaint was already made about the Italian Mar Nostrum policy in 2013 to 14, and has since been mobilized against humanitarian NGOs engaged in search and rescue. So Frontex wheel this out on a regular basis. Second form, humanitarian government directed solely at the goal of reducing overall suffering fails to acknowledge the importance of the distinction between persons, that each person matters. So hence it's liable to produce outcomes that are, from the standpoint of the picture of the humanitarian ideal as constraint, wrongful. One way of negotiating this tension is the construction of justifications for why some should be treated differently to others. That is, drawing a set of normative distinctions designed to distinguish those seeking irregular entry from the wider population of refugees, and offering a moral justification of differential treatment in the service of reducing overall suffering. So the classic examples of this are the Australian invocation of the idea that people who arrive by boat were queue jumpers because Australia had its fixed quota of refugees and they were trying to kind of get in on another route. And the UK currently in relationship to boat crossing from France. So a key part of this strategy is introducing a hierarchy into the field of refugee protection that distinguishes those who conduct themselves appropriately according to what are presented as the proper norms, and those whose conduct breaches such norms. In neither case does this hierarchy simply deny that the latter are entitled to humanitarian protection. Rather, it exploits it as a reason for the denial of protection here, by presenting protection here, Australia, UK, as rewarding wrongful conduct and doing so in a way that encourages others to imitate it, where this increases the risk of outcomes that are bad from a humanitarian perspective. So what we have then are these two ways in which the tension within humanitarianism, constitutive tension within humanitarianism, lends itself straightforwardly to kind of a legitimating discourse in relationship to border externalization. This should not surprise us. Humanitarianism is the language of the advantaged speaking to the disadvantaged. It's a feature of humanitarian government, as Didier Fassin points out, that it's characterized by an internal tension between a relationship of inequality domination and a relation of solidarity assistance. Border externalization is a practice of the advantage towards the disadvantaged, aimed at sustaining opportunity hoarding, that can mobilize that language of humanitarianism against the background of the principle of territorialism to legitimate its activity. Okay, what does this need in terms of response? And I'm very near the end. Any response needs to have two levels: addressing the immediate problem and addressing the sources that generate the problem. So in terms of the immediate problem, I'm kind of broadly in favor of a view that says, duties kick in at the point that you're subject to state power, not the point at which you reach the territory of the state, and a strong norm of non-cooperation with border externalization by other actors. But that by itself doesn't get rid of, if you like, the sources that generate and seek to legitimate the practice of border externalization. There, it seems to me, we need to reframe the question of the legitimacy of the state in global system terms. And you can kind of see responsibility to protect, sustainable development goals, the way Joe, Karen's and I and Gillian Brock have tried to think about refugee systems in those terms. Maybe introducing an international form of citizenship via the UN, where refugees have free movement rights and carry, as it were, portable rights of welfare and stuff with them wherever they go. And most fundamentally, perhaps, displacing the politics of compassion, humanitarianism, with that of dignity, where it's not compassion for the suffering of another, but indignation at the treatment of the other, which is the main driver, to embrace, as it were, the fact that dignity is the language of the disadvantaged speaking to the advantaged, not humanitarianism. And I'll stop there. Thank you.
All right. Is this audible to you, David?
Yep.
Wonderful. So fancy. All right. So we'll now take Q&A from the audience in person, and any questions from the webinar audience can be written in the QA form and will be fielded by our moderators here. So.
Hi, David. Thanks. It's Patti. It's Patti. Anyway, I can't tell if you can see me. You can hear me. We're good.
I can hear you.
Okay. I think your solutions are great. I'm curious who does them.
Yeah. Okay. So nobody does them, or at least nobody does there is no extension as yet in international law of duties to go with the reach of global power. Non-cooperation, I think, does happen, but typically just by migrants and citizens to some extent, not by other bodies. But that doesn't mean there isn't scope there for doing that. In terms of the broader background, removing the sources stuff, I think that there is some, which is why I mentioned responsibility to protect, sort of shifting away from, as it were, the kind of sovereign state individualism kind of model. And I think that impending doom, i.e. climate change, may focus things more in that direction. But yeah, basically, this is a kind of sketch of what's needed to address it, not a sketch of, well, who are the agents who will engage in that process. I thought I kind of tried to cover enough, but as you know, I'm kind of in favor of setting up, if you like, underground railways for refugees and asylum seekers to cross over into British territory. I think that's entirely legitimate. So significant levels of, if you like, refusal to cooperate with the state would be, if you like, a first step forward.
I have a follow-up question, David. This is Micah. To your last point, it's to your last point about displacing a politics of compassion with a politics of dignity. I'm wondering if you think that does, if taking away the sort of logic of humanitarianism will have any material effect, or you think would have any material effect on the on externalization practices, or would simply take away the ability of the sort of use of humanitarianism as a justificatory framework. So are you just saying like, okay, so we take away the ability of Tony Abbott to say, oh, this is for your own good? And what's the sort of upshot of that beyond just externalization continues, but with a different justificatory mechanism?
I mean, it is the justificatory mechanism that's shifting there. My hunch, if you like, or my wager, is that the language of dignity is much harder to set up border externalization in terms of, because, you know, remember, part of the background here is the displacement of the refugee as a figure of rights by this understanding of the refugee as a kind of subject of needs, as it were. So the moment you reinstate a view of refugees as subjects of rights, several things happen. For example, you know, you start talking about self-government rights in relationship to refugee camps. you start talking about, the issue of movement rights, mobility rights, how mobility intersects with other rights that refugees have. For example, family reunion rights, rights to, as it were, employment and education. So those kinds of things all immediately kick in. So the terrain on which externalization has to be justified, and of course, it's likely states are going to try to engage in that, but the terrain on which they have to do it is shifted in a way that I think makes it at least harder for them to produce a compelling justification. Humanitarianism makes it really easy. Okay, I mean, it's really easy. And more particularly, states want to keep us within that game. So they're very happy if other people are making criticisms of their policies from a humanitarian point of view and saying, oh no, this is terrible. Look at all the migrants suffering in Libya, because as long as the focus stays at the humanitarian level, the idea of refugees as members of global political society who have standing and status, who are entitled to rights, who are entitled to lives of dignity, which means some capacity to choose and shape their environments and go about, their lives. Those are kind of kept off the table. So in a sense, in a way, for states, the most important thing is sustaining the humanitarian framing, rather than, in a sense, whether they are winning or losing a particular argument against, humanitarian NGOs.
That's very helpful. Thank you, David.
Hi, David. Robin here. So yeah, that was a great talk. Thank you so much. And I really like this analysis of tensions within humanitarianism. But I wonder what the role of dehumanization is in that story, because the construction of differences doesn't just happen within the humanitarian framework, right? It's not just that some are more deserving than others, but what we see, I think, is a kind of rhetorical, discursive, but also quite kind of effective dehumanization of refugees. So the fact, of letting people die in the forest at the Polish border, or pushing them back at the Greek-Turkish border or in the Mediterranean, and the complete indifference to that on large parts of the establishment in Europe, it goes beyond just saying that there's different levels of deservingness or something like that. I mean, I think it can only be upheld by kind of dehumanization that makes this massive violence somehow palatable and compatible with the self-image of Europe as a humanitarian entity. And if that's the case, so first I wondered about the diagnosis, and but if that's the case, I also wonder about the response, because it's then, let's say, the language of dignity and reinstating the subject of rights, is that enough of a response? Because it seems that vocabulary has been mixed up in that process of dehumanization, right? I mean, yeah, I just wonder about that. Don't we need another vocabulary and maybe go beyond that language of the subject of rights that has been part of that problem of dehumanization in the last couple of decades in European refugee politics?
Thanks, Robin. I think that's a really, really good question. So I'm, of course, just attending to the way in which the language is used and exploited for kind of legitimation purposes. It is, of course, quite right to say that what's actually going on goes beyond that and extends towards dehumanization. But of course, that's just the predictable, terribly unfortunate effect, okay? Where states will, in the UK, we've just had another report into, appalling racist and violent abuse of people in detention centers, okay? And we have one of these, on a fairly regular basis. And of course, it's terrible because detention centers are a perfectly legitimate tool and it's simply abuse. And of course, that kind of rhetorical move is exactly the move that will happen in relationship to what you're talking about. So, the language of humanitarianism is used for legitimation purposes, but the practice itself engages in dehumanization. So I'm kind of completely with you on that. Does that mean that we need to get rid of, or we need something more than the language of dignity? Okay, I know my stress is on dignity more than rights here. So maybe, or at least we need more than some languages of dignity. But I'm kind of influenced here by the kind of tradition of African-American political theory, or more generally, if you like, with Black political theory of the Atlantic, or the Black Atlantic, in which dignity is absolutely central from kind of Frederick Douglass at least on. So James Baldwin's kind of reflections on this. So I think for me, getting that idea of dignity that comes out of the, if you like, Black radical tradition to do some work, which of course I didn't talk about here, I just mentioned those, actually provides us with some grip. So we don't have to go for the normal pale Kantian conception of dignity, for example. But whether that's an adequate response to your question, I don't know. I think it's a really great question.
Hi, David. This is Ayten. Thank you so much for your presentation. I have two quick comments, maybe more than questions. The first one relates to your really great critique of humanitarianism, and I'm wondering whether we also need to bring into that critique the history of humanitarianism and its entanglement with empire. We think of justice, dignity, equality in relation to certain people, but we think of humanitarianism, compassion, with regards to other people, and there is a history to that. And I'm wondering whether we should take that into account. The second point, you had that really interesting quote on basically jurisdiction, right? Jurisdiction understood in a very territorial way, which would also mean that many decisions would actually, basically be exempt from this kind of scrutiny, such as visa decisions. But there is an alternative notion of jurisdiction that is being pushed by international human rights lawyers, activists on the ground, which is this, what is often referred to as the functional notion of jurisdiction, which we see, for instance, in the Hirsi Cema and others, Italy decision of the European Court of Human Rights, where the court ends up adopting that vision. And in the US case, it would be basically with regards to Guantanamo, Boumediene v. Bush, where basically states exercise jurisdiction not only in territorial terms, but also each time they use coercive power. So the coercive power, the use of coercive power also can trigger jurisdiction, which might mean that something like a visa decision would also be subject to scrutiny on the basis of human rights norms, as well as norms such as the non-refoulement. Thank you again.
Yeah, thanks, Ayten. On the first point, I entirely agree with you, and obviously something like Polly Pallister-Wilkins' recent book on humanitarian borders is quite good on that history of entanglement of humanitarianism in empire. I mean, the kind of European view seems to be that humanitarianism basically emerges with the International Committee of the Red Cross in the late 19th century, 1870 something. But actually, as historians and scholars like Pallister-Wilkins have shown, it actually has a kind of longer history and is much more bound up with that history of empire. So I think you're entirely right about that, and if anything, that just kind of, in a sense, reinforces my skepticism that humanitarianism is very much about the attitude of the advantaged to the disadvantaged. On the second point, the functional point, I'm sure it's my fault because I was probably just going too fast at the end because I knew I was already slightly over line. But that was basically the view that I took myself to be endorsing, that, as it were, duties kick in at the moment you're subject to state power. So it's a kind of more functional view. So I mean, this isn't something I've thought of. This is very much something that Eilert Shahar and others have who are kind of lawyers and know that stuff better, have been proposing. So I'm basically entirely brought up for that. My point in relationship to it was to say, yeah, but in a sense, even if we can do that, even if the international lawyers are successful in getting that, you know, kind of well established in international law, it still doesn't kind of address the background, you know, in a sense, sources that push towards policies like border externalization. And for that, we actually need to kind of transform how we think about the state. Okay, how we think about legitimacy of the state, but also how we see other people. So that's the view. But thanks very much for the comments. I agree with you.
Thanks so much for this talk. I'm wondering about your use of the term refugee through the talk, especially as you start with a critique of the convention. And I tend to teach the term by its legal definition, limits and all, but I sense as you're using the term, you've already early in the talk developed a criticism of this idea that certain causes for displacement or suffering should not be valued over others because of the arbitrariness of those values. But is your argument attached to a particular understanding of the term refugee as opposed to forcibly displaced person or migrant, or is this, you know, something else in the definition or redefinition of the term that you're working toward?
Okay, thanks. So the bit about moral arbitrariness and stuff, that was me reconstructing the humanitarian critique of, if you like, the political definition of the refugee in the convention. And my point there was simply that, you know, not to sort of endorse that critique fully, but to say, look, this is a perfectly intelligible moral critique. Okay, as it happens, it's not one I agree with, but then I think the narrow definition within the convention is also highly problematic. So I do have a view on this, and I kind of wrote a book setting it out in which I tried to give a political account of the refugee, but one that had significantly wider scope than the Refugee Convention, and did not collapse into the humanitarian picture. So I, for example, think that issues around sovereignty and borders still actually matter for the question of who's a refugee. However, I should say that I think the view that I expressed in the just short, you know, What Do We Owe to Refugees book, comes under pressure from the kind of account that Alex Ilenikov and Leah Zamora articulate in the Arc of Protection, where they sort of argue shifting the language to necessary fleers, basically, and obligations to necessary fleers. So, and I've used that framework actually in recent work in relation to displaced Venezuelan women with colleagues. So at the moment, I want to say, well, look, you know, I have a nice, neat account that's political but considerably wider, which I've kind of written and published, and that's my view. But that view is also kind of under challenge, and I'm kind of thinking, well, maybe was I right about that, or maybe I was actually wrong about it. Particularly given the, if you like, practical role in law and policy that distinctions between refugees and other kind of forced migrants can play in terms of access to rights, opportunities, etc. I mean, I think Alex and Leah's book, you know, is good at speaking to the kind of issues that someone like Rebecca Hamlin's work has raised. Okay, does that help?
David, I'm going to ask a question from the Q&A in the webinar. This is from Joe Cairns. How does your argument about the politics of dignity resemble or differ from arguments that justice requires a fundamental transformation of the global order into something much more egalitarian?
Okay, thank you, Joe. I mean, it does require transformation of the global order, but in a sense, I want to sort of say that there's a kind of mutual relationship between the language of dignity and that transformation. So on the one hand, the language of dignity can motivate, you know, transformation. On the other hand, transformation as it occurs, or practices, if you like, dignitary practices and policies as they come in, helps sustain and entrench the language of dignity. So I kind of think about them as having that kind of relationship. The language is not, as it were, kind of epiphenomenal. It's actually a crucial part of the process. How we think about ourselves, you know, as Robert Brandom, among others, points out, is partly what we are and what makes us what we are. But of course, one of the problems with a world of radical inequality, kind of highly racialized borders and stuff, is that it actually makes getting the language of dignity off the ground properly into those things hard. So it has to be a kind of relationship between how we think about ourselves and how practices go that is kind of mutually supportive. But that would, of course, lead, as you correctly say and have argued, in a more egalitarian direction.
And one more question from the webinar. This is from Felix Bender. If we reject the humanitarian picture of refugeehood and embrace the political picture, should we re-emphasize a politics of compassion? Should we not start treating refugees as important political actors? Should we not try to cultivate a picture of refugeehood in which refugees are valuable political actors for the states who admit them? After all, states admit refugees to condemn their rivals. Could this be a strategy to combat forms of externalization?
Yes, thanks, Felix. Hello. I think rejecting, as it were, the humanitarian picture of the refugee does reassert a view of refugees as social and political actors who, if you like, need to have the kind of reasonable conditions of social and political agency in terms of shaping their lives and environments. That, it seems to me, requires not just things like, you know, shelter, access to employment, access to education. It also involves political rights, okay? Now, there's some specific legal arguments on this. Ruby Ziegler's book on voting rights for refugees was one obvious place to go, but whether it's local voting rights in the first instance, through to national voting rights, I do think that pointing out that refugees can be, and often have been, incidentally, valuable political actors matters. It also matters in terms of relationships to the refugee producing states and those in its neighborhoods afterwards. So refugees, and Ashwini's recent book on the ethics of exile, I think, is really interesting on this, that those who are refugees taken in as political actors, as they were in the immediate, kind of post-51 European context, that they are able to play roles in relationship to kind of reconstruction, transformation of their home state, and roles in relationship to the region. So, if you like, kind of refugee transnational political activism and diplomacy is also something that, I think could be positively embraced by treating refugees as political actors to whom we give political rights in the hosting state.
All right, I think that's all the time we have for our first talk. Everyone, please thank Professor David Owen for his talk. And I think we're going to just slide right into, since we're already over time slightly, into Ayten's talk. So our next speaker today is Ayten Gündoğdu, who is Tao, Associate Professor of Political Science at Barnard College and Columbia University, and who will be presenting on the lawful lawlessness of borders, rethinking extraterritorialization as a technique of racialized governance.
Oh, okay, we are seeing this too. Good afternoon, everyone. I want to start by thanking everyone involved in the organization of this seminar, and especially Micah for inviting me, and for Chrissy for arranging all the logistics. I'm really, really pleased to be here with David and Patti discussing this difficult topic with you. Thank you for being here, and thank you for being on Zoom. I'm going to be basically try to navigate this. Let's see if I can. For some reason, it's not working. I'm trying to press the next. Oh, there it is. Okay. Okay, so it seems like I figured this out. My presentation for the seminar is based on a chapter in a book manuscript that I'm currently working on, which examines migrant deaths and disappearances in the Euro-Mediterranean region by engaging with the works of Frantz Fanon, Hannah Arendt, and Judith Butler, among others. In this book, I'm interested in two interrelated dimensions of this problem. First, this is an institutionally organized and often legally authorized form of state violence to the extent that it is border control policies that systematically give rise to these deaths and disappearances, and courts refrain from condemning the state violence, and oftentimes they legally authorize it. Second, this problem reveals the racialized allocation of rights in life and in death in contemporary border regimes. Not everyone is equally subject to death and disappearance at the borders, and most for very privileged people, borders are actually very, very porous. To understand which subjects become vulnerable to such violence, there is a need to rethink border control policies as practices operating with and productive of racial difference. My presentation is an attempt to think about these two key dimensions in relation to the problem we are addressing in this seminar, namely externalization, or what is sometimes referred to as extraterritorialization of border control. This includes a wide range of practices, including the removal of certain territories from jurisdiction for immigration purposes, interstate agreements to outsource border control to countries of origin and transit, and maritime interdiction of migrants to prevent their entry into territory. Many of these practices have pushed migrants to really, really risky journeys, and they have contributed to an increase in migrant deaths and disappearances. These policies of externalization aim to dissolve the connection between territory and jurisdiction that is central to modern law, as we saw in David's talk. Continuously shifting and manipulating borders, they aim to create what we can call, following Hannah Arendt, conditions of rightlessness. They deny migrants access to territory, they push them outside jurisdiction, denying in effect personhood before the law and the right to have rights. To briefly sum up my argument, I propose rethinking these policies of extraterritorialization as one key element in a contemporary constellation of continuously evolving juridical techniques that can be best understood in relation to juridical techniques used by other projects of racial domination, such as colonial rule. I'll argue that extraterritorialization, and more broadly, the juridical regime of border control within the Euro-Mediterranean region, is a form of lawful lawlessness, which involves strategic manipulation of law itself, including human rights law, to create zones of lawlessness and rightlessness. Let me briefly outline how I will develop this argument in this presentation. First, I will clarify my use of the term lawful lawlessness, and I will also try to clarify why I'm thinking about these two very different contexts, colonial rule and border control, together. Second, I'm going to discuss the peculiar monstrosities of colonial juridical orders, their lawful lawlessness, and then I'm going to move to a very specific border regime, the Spanish-Moroccan border, and focus on these two towns, Ceuta and Melilla, to show how the legal techniques of racial domination that we see in the colonial context are reconfigured in the governance of this border that has been a famous site of pushbacks against migrants arriving from sub-Saharan African countries. Fourth, I will discuss how the racialized violence of border externalization is authorized by law itself, and I'll do that by turning to a 2020 ruling of the European Court of Human Rights in the case of ND and NT v. Spain, which concerns a Spanish pushback operation. Within the scholarly debates on externalization of border control, there is a tendency to understand these policies as forms of lawlessness. When Australia uses NORA for the offshore processing and detention of asylum seekers, for example, or when Italy enlists Libyan militias to stop migrants from crossing the Mediterranean to Europe, many analysts consider such acts as striking aberrations from the principles of the rule of law and international human rights norms. But in understanding the problem as one of lawlessness, I think we risk overlooking how law plays a crucial role in border externalization. States mobilize and manipulate law to create forms of lawlessness, and they are manipulating not just state law, but also international human rights law for this purpose. Additionally, it's not just state courts, but also international courts, in this case, the Human Rights Court of the Council of Europe, European Court of Human Rights, that is providing externalization and other coercive methods of border control with an aura of legitimacy. To capture this paradoxical situation in which the lines between what is lawful and unlawful, what is arbitrary and legitimate, are increasingly blurring, I'm adopting this term lawful lawlessness, and I'm borrowing that term from two legal scholars, Austin Sarat and Nassar Hussain, who propose it in a very different context to understand actually executive clemency in cases of capital punishment in the US. So they are interested in occasional discretionary exercise of sovereign power in a constitutional democracy that otherwise rests on a legal system of predictable rules. In that sense, my use of the term is different. I'm taking the term, borrowing it from them, to basically describe an entire juridical order, not just sporadic acts of discretion, but an entire juridical order in which lawful lawlessness itself becomes the norm rather than the exception. I suggest that we see such a situation whenever law is placed in the service of racial domination. To make this argument, I reconsider the juridical techniques used within the context of border control, including the kind of jurisdictional manipulation that we associate with externalization of border control, in light of the juridical techniques that were introduced by European imperial powers in their colonies. In thinking about these two different contexts together, I'm not asserting a causal linear connection between the two. I'm not saying, in other words, that colonial juridical regimes underlie contemporary border regimes, an argument that is made in different forms by other scholars. Rather, I suggest that thinking these two contexts together, despite their differences, can illuminate how the distinction between lawfulness and lawlessness explodes in systems where law is put in the service of race rule. I will now turn to the colonial context to identify some of the juridical techniques and formulas that I associate with lawful lawlessness under racial domination. And I rely heavily on British and French cases, particularly French colonialism in Algeria, mainly because one of the key thinkers I'm working on is Frantz Fanon. Law was crucial to racial domination under colonialism, both as a justificatory framework in order to authorize violent practices, but it was also a productive mechanism that created jurisdictions and statuses used for the differential allocation of rights, privileges, and penalties. One key element of colonial juridical orders was the manipulation of jurisdiction, particularly the use of multiple and often conflicting concepts of jurisdiction to deny the colonized equality before the law. In the case of French colonialism, for example, the French state worked with a territorial conception of jurisdiction to assert its sovereignty over colonial territory, but it also simultaneously marked that territory as an exceptional space where French laws did not apply. This territorial exceptionality went hand in hand with another notion of jurisdiction based on status that created racialized distinctions between the settlers and the colonized. For example, the French Code de l'Indigène, introduced first in Algeria and then in the rest of the empire, subjected the colonized populations to an arbitrary rule by decrees, established legal status distinctions between the natives and the settlers, and codified their racial inequality before the law. The legal construction of racial difference was central to instituting racial segregation under colonialism. Within this system, the movement of the colonized was subjected to an elaborate system of controls, including the use of internal passports for colonized subjects to leave their home districts. All these deviations from the modern idea of equality before the law were justified according to colonial powers due to the special conditions of the colony. As a result of this exceptionality, law operated in a more or less permanent emergency in the colonies, with the use of continuously changing and arbitrary decrees laid down by colonial administrators. Within this regime of exception, punitive measures, normally deemed unacceptable under the rule of law, were permissible. We can see, for example, the routinized use of collective punishment and administrative internment with no right to appeal and no time limit. This regime of exception was also a regime of impunity, in which it was extremely difficult to uphold colonial officials or non-official Europeans even accountable for the use of violence against the colonized. While the colonial regime exempted the colonizers from any culpability, it also rendered the natives suspicious in the eyes of the law on the basis of a set of racist assumptions about the innate characteristics of the colonized, including aggressiveness, mendacity, irrationality, and criminality. We could recall here Frantz Fanon's scathing critique of the Algiers School of Psychiatry and their thesis of North African criminality, according to which the North African was predisposed to criminality because of congenital defects tied to the underdevelopment of their cortex. The colonial juridical regime, in short, turned the colonized into rightless entities who could be subject to arbitrary rule and violence with impunity. I will now turn to contemporary borders to clarify how some of these elements of lawful lawlessness are reconfigured within a new form of race rule. I'll be focusing on the Spanish-Moroccan border, the border towns of Ceuta and Melilla. These towns are Spanish enclaves located in the north of Morocco, and they constitute Europe's only land borders with Africa. And as a result, they are heavily fortified. Between the Spanish and Moroccan sides, there are 3 6-meter high fences equipped with anti-climbing grids and topped with barbed wire and razor blades. The Spanish-Moroccan border is a site known for pushback operations. Each time migrants manage to scale the fences and reach the Spanish territory, they have been forced back by the Spanish Guard as well to the Moroccan side and handed to Moroccan border guards. One of the bloodiest of these pushbacks took place on June 24, 2022 in Melilla, when the Spanish and Moroccan forces violently thwarted the efforts of over 1,500 migrants, mostly from Chad and Sudan, to cross the border to Spain. Described as the deadliest incident in the history of the Spanish-Moroccan border, the brutal operation led to the death of at least 37 migrants, and there has so far been no justice for these deaths. What are some of the elements of lawful lawlessness that we see within this border regime? If we recall, a signature move of colonial powers was to manipulate different conceptions of jurisdiction to mark their colonies simultaneously as their sovereign possessions and as exceptional spaces where their laws did not apply. We see a similar technique of jurisdictional manipulation in Spain's notion of operational border. Spain asserts sovereignty within Ceuta and Melilla, which should mean that the 3 fences are within its territorial jurisdiction. But it also argues that migrants enter Spanish jurisdiction only after climbing over the 3rd fence and crossing the last line of Spanish security forces, which is continuously shifting. So when migrants die and disappear as a result of Spain's pushback operations, as was the case in June 2022, the Spanish government invokes the notion of operational border to evade any responsibility, declaring that the events did not take place within its territory. Extraterritorialization, similar to the colonial tactic of manipulating jurisdiction, aims to create zones of exception where rights and legal protections can be evaded. Not unlike the colonies, it goes hand in hand with juridical regimes that operate with racialized status distinctions. We assume that such status distinctions have become obsolete in modern law, even more so with the rise of human rights. However, in the migration context, we see them all the time, these status distinctions, to the effect of rendering those categorized as irregular migrants ineligible for many rights. What is more, given how border control operates today, these status distinctions are racialized. The so-called mobility partnerships that the European Union signed with Morocco, for example, make it nearly impossible for most sub-Saharan Africans to enter Europe through regular means, as they single out this group among 3rd country nationals to be returned by Morocco. As a result of such mobility partnerships, nationals of sub-Saharan African countries have been increasingly immobilized, and they have been subject to violence, as exemplified by the brutal pushback in June 2022. Such violence has become routinized in a normalized state of emergency, justified on the basis of assumptions about the peculiar characteristics of borders as spaces of exception, which is another way in which the colonial context, I think, can illuminate the lawful lawlessness of contemporary border policies. In the case of Spain, for example, the Aliens Act of 2015 established what is called a special regime in Ceuta and Melilla, which means that the Spanish authorities can expel migrants suspected of illegal entry back to Morocco without any inspection of their individual circumstances. This special regime is also a regime of impunity in the sense that no Spanish border guard or state official has been held responsible for the pushbacks, even in the case of deaths. While state agents have been exempt from culpability, it is now migrants who have been assigned culpability, as their efforts to cross the border collectively are described by Spain as quasi-military attacks that justify the use of anti-riot gear and anti-riot tactics. This militarized discourse of invasion and enemy is tied to a racialized imagery of Africa and Africans within the European immigration context, so much so that the simple act of scaling a border fence has come to be seen as an act of belligerence against a state. Let me now try to briefly explain how this racialized justification of border control has recently been accepted by the European Court of Human Rights in its 2020 ruling of ND and NT v. Spain. This case concerns a pushback of two migrants by Spain to Morocco, ND from Mali and NT from Ivory Coast. They were part of a group of around 600 migrants who tried to cross the Spanish-Moroccan border through the border fence in Melilla in August 2014. They succeeded in doing so, but the Spanish authorities immediately returned them to Moroccan authorities without conducting any identification procedures or any assessment of their individual circumstances. The question before the court was whether Spain violated the prohibition against collective expulsion and the right to effective remedy by depriving these migrants of the means to challenge their immediate return. In 2017, a chamber of the European Court of Human Rights found violations on both counts. But following Spain's appeal, the Grand Chamber delivered a strikingly different ruling in 2020. The Spanish pushback did not amount to a human rights violation, the court concluded, because it was, and I'm going to be quoting from the ruling itself, it was in fact the applicants who placed themselves in an unlawful situation as they chose not to use the legal procedures to enter Spanish territory lawfully, unquote. The ruling in this case highlights the need to examine the shifting constellation of techniques mobilized for the racial governance of borders, rather than focusing solely on extraterritorialization. While the court rejected the arguments the Spanish government made to evade jurisdiction, including its concept of operational border, it ended up upholding various techniques associated with race rule. The court took on board the Spanish government's image of invasion by migrants, as it placed particular emphasis on the fact that the applicants, ND and NT, were part of a large group crossing the border collectively, irregularly, and disruptively. The court also underlined the strain, the extreme strain placed on the European states by the large numbers of migrant arrivals due to political and economic crisis in, quote, certain regions of Africa and the Middle East, unquote. This logic of emergency, conjuring images of invasion, was invoked by the Spanish government to shift culpability for the collective expulsion to the applicants themselves. In fact, the Spanish government, the lawyer for the Spanish government during the oral hearing of the case constantly emphasized that the real victims were not ND and NT, the real victims were the Spanish state, the Spanish people, and the European citizens in general. The court agreed with this reasoning, concluding that the applicants would not have been summarily expelled if they were not entering in an irregular and disruptive way as part of a collective. Such reasoning renders human rights conditional on arbitrary interpretations about the culpable conduct of migrants. But it's also even more sinister than that, in that it turns unauthorized border crossing into a de facto status crime when undertaken collectively by subjects who are perceived to be threatening. And determinations of culpability assume racialized overtones within the context of the Spanish-Moroccan border, as I tried to explain earlier, since this kind of culpable conduct, what the court refers to as culpable conduct, is most likely to be undertaken by migrants from sub-Saharan Africa who are systematically denied access to legal entry procedures. It was precisely this racial dimension of the problem that was disavowed in the court's ruling, that refused to take into account numerous forms of evidence submitted by third parties, including the UNHCR, which unanimously highlighted that nationals of sub-Saharan countries are systematically denied access to regular border crossing points and asylum offices of Spain, and that they had no option but to enter Spain by climbing the fences. On the slide, you see a chart created by Forensic Architecture. This is a research group that has participated in investigating numerous state crimes, including those that relate to border control. And it's a little bit perhaps difficult to see, but it shows that at the Beni Enzar crossing, which was opened a few months after basically the pushback took place, the pushback in question took place. Within a period of almost 3 years, from September 2014 to May 2017, you see over 9,000 applications, asylum applications, and only 2 of those applications are from nationals of sub-Saharan African countries, both from women covered in a full burqa in order to escape racial profiling. Despite the overwhelming evidence demonstrating racial discrimination, the court simply noted that the reasons for this disparity were not exactly clear. It refused to recognize, in effect, a systemic form of racism, which takes us beyond individual prejudices and centers on the racial disparities arising in the implementation of seemingly colorblind policies. The court's reluctance to recognize systemic racism is combined with racialized assumptions about disposition to law-breaking, giving rise to what we could call, following Fanon, sub-Saharan culpability thesis. Within the final ruling of the court, we see a racialized image of a violent horde taking advantage of their large numbers. Taking advantage of their large numbers is a quote from the ruling itself again. Acting stiltily, the court says that they frequently operate at night in order to produce a surprise effect and attacking the borders of Europe and storming the fences. The phrase storming the fences appear again and again in both the Spanish government's depiction of the event and the court ruling. It's this racialized imagery, along with the logic of emergency triggers, that is used by the Spanish state and the European court to justify punitive measures that would not normally be allowed under the rule of law, including collective expulsion, which is a form of collective punishment. I'm going to now try to sum up very briefly the main conclusions of this research. First, there is a need to rethink contemporary border policies, as I try to emphasize here, in relation to other projects of racial domination. We need to think historically in many respects as we think about these contemporary policies. Such an analysis cautions us against the tendency to see certain policies as unprecedented aberrations from liberal democratic norms and principles. Second, such an analysis also draws attention to the law's own involvement in maintaining and authorizing the regime of impunity surrounding the racialized governance of borders. That conclusion points to the problems with understanding border violence as one of lawlessness. Not unlike the lawlessness justified by law itself under colonial rule, lawlessness in border control goes hand in hand with a certain form of lawfulness that generates an ever-expanding repertoire of formulas invented to evade human rights and the rule of law. Hence, my proposal to understand this regime as one of lawful lawlessness.
Either from here or the webinar audience. I'm happy to start us off, if you don't mind, Ayten. Thank you very much for your talk. That was wonderful. So your initial discussion of the way that these tactics and techniques blur the line between law and lawlessness, legitimacy and arbitrariness, you described that as, I took it, the function of that primarily in terms of creating zones of exception that allow the state to act with relative impunity. But I also wonder if there isn't a secondary function, or whether you would reject this, that there's a sort of, that same blurring of those lines also functions as a program of deterrence, right? Where you can imagine that serves to signal to would-be asylum seekers that lawlessness and arbitrariness are sort of real and permanent risks of any attempt at movement towards the border. And I'm thinking of this partly in terms as well of like Fanon's claim in Wretched of the Earth that one of the central logics of colonialism is containment, the attempt to sort of regional containment of populations. And so I wonder if you think that there are sort of secondary functions that are also normatively significant.
Thank you so much, Marka. Yeah, so one function is definitely creating this kind of, state of exception, right, where the principles, norms that we would normally associate with the constitutional order are simply not working. First of all, there is no equality before the law. That is not working, right? That is basically one of the things. But one of the other things I want to emphasize here was basically another function, or where we see this kind of lawful lawlessness emerging not simply as an exception, but rather as a norm in a juridical order. I suggested that this happens particularly when law itself is placed in the service of racial domination or race rule, where basically race rule referring to an order in which racism becomes an organizing political principle in terms of basically the governance of that order. And so that's another function. That's actually, for my purposes, that would be the key claim that I'm making. Within the context of border control, when we think about externalization policies and how these policies systematically give rise to death and disappearance, there is definitely that deterrence function that states have in mind. Some scholars basically refer to this idea of death as deterrence, right? Death itself is used as a measure of deterrence. We have now statistics of migrant deaths and disappearances collected by various organizations, including the International Organization of Migration, but those statistics are sometimes also invoked to basically deter migrants from making these journeys in the first place. And sometimes I think IOM, despite maybe there are some very well-intentioned people working there and interested in this question, the way the data is presented sometimes is really, it seems to have that kind of, effect of deterrence. So deterrence is definitely part of it, but I think we have to think about deterrence, given who is being deterred, also in relation to the key claim that I am trying to make about the connection between lawful lawlessness and race rule.
Thanks. Thank you for that. I learned a lot. I'm looking forward to talking more about it over dinner. I have two questions. One, which is just actually about that graphic that was hard to see, which showed that, which is just, can you say more about that and why it would be, I mean, your explanation or your conclusion there was that there were 2 asylum applications that were made. And I'm so sorry for this question. Did you mean accepted? Like there were 9,000 claims made, 2 were accepted, and they were both from fully covered women. And your conclusion was that that was because they were covered, so people couldn't see what color they were. I guess I'm not skeptical. I believe everything you say. I agree with everything you say. But let's say I were skeptical. How would you know that? Like, what would be the signal? Because I would think that that anybody at that border would just assume that anybody coming from sub-Saharan Africa is Black. Mm-hmm. So I would, even if there were covered. So I'm interested in more about how you drew that conclusion. And then the second question I have is also, I'm not skeptical. I agree with everything you say. So I see this, I'm very persuaded by this claim that what's going on at the border is that states are creating laws and people have to make just decisions about how to operate around them, which appear as lawlessness, right? So we see these pictures of people rushing borders or people trying to climb fences. It looks like, I mean, people are just responding to the incentives and the structures and the constraints that are around them in totally reasonable ways. If you were desperate, if I were desperate, I would do that too. We would all do that. That's entirely predictable behavior. And again, so my question is, again, I'm not skeptical. I'm not skeptical. Okay. But what does the colonial analysis add to this? because it seems to me that actually I could just tell this story as one of poverty, right? That Western countries don't want poor people sucking up their resources. And so they erect all kinds of difficulties so that people who are poor can't access the benefits of the West. So I guess I would just like to hear more more about why I should understand this as racial discrimination or as a legacy of colonialism rather than just classism, say. Not skeptical.
Thank you. Thank you, Patti. So with regards to the first question, so as I said, the image that I'm using on the slide that I tried to put up there now too, is coming from forensic architecture. And on that image, you see basically during that period, September 2014, May 2017, there are over 9,300 asylum applications. Only 2 of those are from sub-Saharan African countries, only 2. And the total number of asylum applications is over 9,300. So the way that number has been used by asylum advocates in this court was basically to show to the court, to demonstrate to the court that it is almost impossible for sub-Saharan Africans to even access these border crossing points of Spain to claim asylum, because they are going to be immediately taken care of by the Moroccan border guards. Whereas the treatment of Syrians, for instance, will be different. So the asylum applications, the total number will include, for instance, Syrians, but the total number of sub-Saharan applicants, 2 in that period, close to 3 years. And the claim about the 2 women, the fact that these were 2 women covered in burqas, comes from European Court of Constitutional and Human Rights, which were involved in the litigation of NDA and NT with Spain. And they have this in a report, basically, as one of the facts they shared. And their conclusion, it's their conclusion that they did this precisely to avoid racial profiling, precisely because everybody knows that racial profiling is such a common instance, particularly racial profiling against sub-Saharan Africans is so common within this border region. So that's basically their finding. In the case of the second question, so what does colonialism add? In some respects, we can say basically this is showing us the intersection of race and class, right? It doesn't have to be one or the other. But the way colonialism is adding to this story is not that, I don't want to say these are the legacies of colonialism. That's why I said I'm not drawing a direct analytical link between these 2 different contexts. I'm not saying that Spain, when they formulate their border control policies, they basically look at all these old French colonial laws. What I'm saying is that if we were to think these 2 contexts together, and the similarity being they are both, according to me, examples of race rule in the sense that racism is used as a principle to organize that juridical order, we basically see striking similarities. And we might be able to learn things that we would not otherwise learn if we were not to put them together. That doesn't mean that we shouldn't consider other things. We should, of course, consider, gender, class, ability. All of these are important things in the context of migration. So this is one important key thing, really taking seriously some of the arguments that scholars have been making about basically the racialized operations of borders, and thinking about how, juridically speaking, although we have a tendency to think of the law as a colorblind space, how this might operate even in basically these, this might be manifest even in juridical techniques, even in courts of law. That was the idea. Thank you.
Yeah, thank you so much, Ayten. This was, again, a great talk. So I stand to focus on the, let's say, the territorial logic of the border and also how it's pushed outwards. And that's extremely important. But I was wondering whether you would also consider the fact that the border is also internalized in a way and moves with those who actually manage to cross the physical or the territorial border. And a similar logic like the one that you analyzed seems to occur there, right? I mean, in terms of certain migrant or refugee populations then being subject to, well, deportation, exploitation, over-exploitation, whatever you want to call it, in ways that others are not in the same sense or to the same degree subject to. And well, and in a way you could argue that the same is already evident in the colony, because the colony is not just, let's say, a space of acceptance, but it's also something that follows the colonized subject. I mean, Fanon is a good example for that. What, even if they go to the metropole, study there, become fully educated, integrated, whatever it is, how you want to describe that process, still that kind of logic of the colony will not let them go in a way, right? So I was just curious whether you would consider that as a natural extension of your argument, or is there a different logic at work there once we leave the physical space of the border behind, as it were?
Thank you, Robin. I would completely agree with that statement, which I take to be, it's not the border. There's another way in which the border is functioning, right? Basically, the border is not only the physical line, partly because states are constantly moving it and changing it, redefining it, partly because of these externalization policies that we are talking about, but also bodies themselves are basically carrying these borders with themselves, right? But there too, why certain bodies, right? Why it's easier for some people for some bodies to navigate borders and also the countries that they move to much more easily than others, right? One of the striking claims that Fanon makes is that he didn't even basically think of, he didn't have this kind of awareness of Blackness until he went to France, right? So I think even when we shift our attention from the physical line of the border to bodies as borders, I think we need to bring that question of race, and then importantly for my purposes, also how those bodies are regulated and governed in and through law, right? What is their relationship to the law? How the law treats them, in other words. When I present this work, I presented this work at Brown University a few months ago, maybe even earlier this year. And so I'm making these, I'm saying there are these striking similarities between these two very different juridical regimes, both of which can be identified as race rule. Scholars of basically American politics, especially scholars of African American political thought, also refer to laws of slavery as another place where I can look at to actually support this claim. And I teach this in a class on law and violence, and I agree with this. It could be, I'm not making it because it's going to make it, even when I present it right now, here are two, racial orders, colonialism and border regimes, it gives rise to reactions. And if I add slavery too, it's going to give rise to even further reactions and probably objections. But that's another place where basically we see how the bodies, when we think about, for instance, fugitive slave laws, right? There too, we are seeing the bodies themselves as carrying the borders within and being subject to violence as a result of this organizing principle of racism within that order. Thank you.
I believe there's a comment from David. You have your hand raised. Do you want to, I believe you can unmute yourself.
So thanks, Ayten. That was absolutely fabulous. And you gave Robin everything that he felt was kind of missing from mine. So I really enjoyed it. The question that I wanted to ask, since I basically don't disagree with the argument, is how much of your argument is specific to the Euro-Mediterranean? So, you know, I mean, I'm thinking, for example, since she's there, of Elizabeth Cohen's work in Illegal on the kind of racialization of the Mexico-US border and the operation of constitution light zones in which, you know, by ICE, where protections don't come in, and I can see analogies there. But the one that's kind of struck me, partly because I've just been looking at it, is South America. And this is to kind of point to the kind of salience, this is partly in response to Patti, I guess, the salience of the colonial history. Because if we think about the way race is figured in a South American context, it's really quite different to the way that race is figured in a European context. But you know, in South America, under the colonial regime, it was a regime for white people to move freely, and then various others at different graduations of color, going down to the bottom, which was black, as it were, to be regulated more closely. And if we look at contemporary asylum practices in Brazil, for example, and I'm thinking of Catherine Jensen's recent book on the color of asylum, where she's talking about the racial politics of safe haven in Brazil. I mean, it does appear that although the kind of racial graduations and overall racial picture is different, that kind of colonial structuring of race is still actually playing out in the way in which asylum claims are dealt with in Brazil. So I kind of want to say, actually, the colonial history really kind of does matter. And so, you know, you should keep that, you know, strong in the analysis. Sorry, that was probably a bit more of a comment than a
Thank you so much, David. So I do work on the Euro-Mediterranean, and I'm less familiar with other regions and how basically colonial histories and racism work in this context. But one of the claims I'm making, as I said, you know, on the one hand, yes, basically I'm thinking about it historically, but on the other hand, I don't want to have this kind of direct linear argument saying that, right, it's the colonial juridical regimes, techniques that are simply adopted in this context. I'm really interested in, I sometimes refer to it during the presentation to this reconfiguration within this constellation of juridical techniques too, right? One of the things that we are seeing, for instance, in the border regime is different from the colonial context. It's a different understanding of status. So we don't basically see race explicitly named anymore. But one of the things that we learn again from Fanon and others is that, you know, when crude racism itself comes to an end, that doesn't mean that racism comes to an end. Racism invents itself. It basically assumes new forms. And one of the things I'm looking at, and it would be interesting to look at it in different contexts, maybe also turn to those who might be examining race in different contexts and colonialism in different contexts, to look at how something that might appear as a conduct, in this case, basically, it is the crossing of a border, right? It seems as if the state is simply targeting the conduct itself, not the status of the person. We don't see, for instance, in the French colonial case, indigène, it's a racial status, explicitly speaking, versus in the case of the border control, it seems as if it's the conduct that is being targeted. One of the things I'm looking at how basically these laws, immigration laws, but also we see it in other contexts too, disaggregate what what is status into into these identifiable individual conducts, right? Such as crossing the border. We see this, for example, in homelessness legislation. Scholars who work on homelessness say how, sleeping in public, it's a conduct, right? But it is going to be an activity that is most likely to be undertaken by those who are homeless. And similarly, in this case, what I'm seeing is that the status distinction is being reintroduced, and it is racialized to the extent that this border crossing, this irregular, unauthorized border crossing, is likely, given basically that graphic, that the slide that we saw, is much likely to be undertaken by sub-Saharan Africans. So I want to maintain definitely the racial and the colonial aspect, but also without subscribing to this kind of linear causal link between colonialism in the past and border control today, if that makes sense, David. Thank you.
Can I ask a follow-up question? And then I want to offer a comment from one of our Zoom guests. And the follow-up question is, to what extent you want to focus on anti-Black racism here? Because you gave the example of possibly Syrian refugees being treated very differently, but they're certainly racialized in other contexts, or David brought up the Venezuelan refugee or migrant who may identify as European, but is certainly treated as a racialized person at the border. And so that's my question about it. Are you interested in anti-Black racism? Is that different, or even a kind of definition of race and racialization processes? And Joseph Cairns, one of our guests on Zoom, asks, isn't law always used by the powerful to sustain their domination, so that its use to maintain racial domination is one important example of this, but not unique? In my mind, those are sort of two connected questions.
Yeah. Thank you. Thank you so much. So with regards to basically this focus on anti-Black racism, this chapter does focus on anti-Black racism, partly because I'm talking about the Spanish-Moroccan border, and that's where we do see basically anti-Black racism. And I think within the European immigration debates, anti-Black racism, that doesn't mean that there aren't other forms of racism, but anti-Black racism, especially the way this category, the sub-Saharan African, it is used and used over and over again in not just debates, but also the documents themselves, as if it was this kind of neutral term that designates a geographic region. But what we realize when we look at how the term is being used, it refers to pretty much, it collapses pretty much the entire African continent, except 5 countries in North Africa that are seen as closer to whiteness. That doesn't mean that they are white, right? They are seen as closer. So what we are seeing perhaps is in the European context, but I think this links to David's earlier comment too, what we are seeing is comparative racialization, right? So I want to think about this bordering process as a process that is productive of racial difference, rather than simply thinking that, oh, there are these racial differences that are out there, and basically these policies are designed to reflect that. Rather, it's the process that is creating the racial difference itself, right? That is attributing to it certain meanings. And in that meaning, there is a hierarchy of moral worth. And in that hierarchy of moral worth, sub-Saharan Africans will be placed lower than Syrians, and Afghans and Pakistanis maybe somewhere in between. Ukrainians will be like, the first, we don't care how many millions, we will just take them in and give them temporary protection, right? So it is comparative, it's comparative racialization, and it is productive of racial difference. And it creates a moral hierarchy in terms of basically judgments about deservingness, who is worthy and unworthy of rights. There is a really interesting book that I assign in my class on love and violence, a really, really great book. Lisa Mary Cacho's Social Death, which was published in, I believe, 2012. And it does talk about this kind of comparative racialization within the US context, right? How one minority group is pitted against another. And how that process itself is one productive of racial difference, generating racial difference, similar to the colonial regimes too. It's not as if they are just basically, we shouldn't assume that racial difference itself is right there, but the colonial juridical regime generates these statuses, and as in doing that, it also produces racial difference. So in terms of the comment on the Zoom, this is also great, and I have been thinking about this, right? So can we, and this goes back to Patti's question too, can we think of, for instance, look at, for instance, the suppression of labor movement within the US and how law was used in that process too, in similar ways? Can we see, for instance, elements of lawful lawlessness within that context too? I would say yes, but I also want to say, and I basically teach a class on law and violence and look at how law has both failed to and also complicit in the production of social inequality. So I would basically look at other contexts too, in which law participates in this kind of problem rather than being the solution. But I also want to, again, thinking about this term constellation, right? This particular constellation with these elements, I see these in these two contexts. And I would be interested if people basically say, well, actually, exact same constellation with those kinds of elements of lawful lawlessness, here it is. And I would very much like that. But these are the two contexts in which I'm thinking about this particular constellation with the elements that I cited, including, the creation of status categories, the fact that they are racialized, the fact that there is basically this regime of emergency, logic of emergency, the idea that this is a zone of exception, and all of that in these two contexts.
All right, I think that's all the time we have. Everyone, please join me in thanking Ayten again for a wonderful presentation.
Thank you. Thank you so much, everyone. Thank you. And thank you to our Zoom audience. Thank you.
We're going to take a 15-minute break now just to recaffeinate, and we'll be back to 4:10. Great.
That's good. That's very serious. You can see this is very serious, Professor.
We're unmuted.
Okay.
All right, we're back, everyone. Apologies for abandoning all the webinar crowd. I'm pleased to introduce our final speaker for today, Patti Tamara Lenard, who is Professor of Public and International Affairs at the University of Ottawa, and will be offering us a talk titled Immigration Fraud as Resistance.
Hi, everybody. So Micah says that the camera will follow me as I walk, and I've been given a microphone because what was the word you used? Because I'm peripatetic. Is that the word? Anyway, it's working. Okay, we're good. All right. So I hate being last. Sorry, Micah, because first of all, you have to pay attention to the other speakers so that you can ask them questions, and then you have to give a talk to a tired room. So got a joke about why is the math textbook so upset? Because it's full of problems. Okay, sorry. Okay, I included that in my time. Sorry. I was actually feeling a bit silly too. So look, actually my talk, which is called Immigration Fraud in quotation marks as Resistance, I think follows really neatly and nicely from David and Ayten's talk already. And so I'm gonna make a couple of claims, and I think that neither of them is controversial, although in order to spice it up, I've called one of them controversial. I'll show you that slide in a moment. For those of you who are keeping track, I have 13 slides. That's the first one, so there's 12 more to come. And actually, I asked a question to David right at the end of his talk. David had a slide up which said, here are the major changes that he thinks the international regime needs to make in order to be more, let's say, more sympathetic to the plight of people who need to flee their countries for various reasons. Let's call them people who are affected by forced displacement rather than just refugees. And I asked, like, who does this? Like, who's going to create an international passport? Who's going to change the sort of the way that we think about the state system? And his answer to me was perfect for me, because his answer was basically, look, the answer is that non-state actors are going to have to do this work, right? It's a non-ideal situation. States aren't that interested in it, and we need to look to non-state actors to make that work. And so, conveniently, for David or me, depending on how you view this relationship, this is actually something that I'm trying to do now, which is try to look at how we should respond, how we can respond to immigration injustice. The world is full of immigration injustice. Nobody in this room and nobody on the Zoom webinar thingo, I think would disagree at this point. We're all in agreement that there's massive injustice, that migrants of various types are the victims of it, that the states that many of us are a part of are explicitly or implicitly contributing to that injustice, and it's like a disaster. Everything's bad. And so what can we do? And so I have this sort of I don't have a sort of project. I have a project. It's a full-on project. It's not a half project. It's a full project, which has 4 parts. It actually has an introductory part also, but it has a 4-part sort of structure, which is trying to look at how different non-state actors can contribute to the remedy of immigration injustice. This talk that I'm going to talk about this sort of claim that I'm going to make today is about how migrants do it, specifically the migrants who are trying to get access to states from which they would ordinarily be excluded. But it has a 4-part structure. One is resistance by political actors and jurisdictions in sanctuary policies. This is where Micah and I met. Where we were both have a lot of interest in sanctuary policies. This is actually sort of state-like because it's sub-state jurisdictions typically that are adopting sanctuary policies, but also resistance by NGOs like Sea-Watch, Carola Rackete, who very famously took her boat full of migrants right onto the Italian territory to say, I am not participating in this nonsense. Resistance by individuals, humanitarian actors, some of whom are unwitting. These are mostly cases in the United States about which I can talk if someone has an interest. And then resistance by migrants themselves. And in this case, I'm particularly talking about the resistance by migrants who are themselves taking the initiative to migrate, rather than organizations formed by migrants after the fact. Okay, and the uncontroversial argument is that immigration fraud, what's described as immigration fraud, is not morally wrong. Excuse me, let me try that in a different register. Lower. Immigration fraud, as it is described, is not actually morally wrong. It may be legally wrong, but it's not morally wrong. So for those of us who are moral philosophers in the room, at least me and Micah, and Robin, definitely Robin. I don't know about everybody else. It's not morally wrong. And the slightly more controversial one is that I want to reconceive it as a form of political resistance. In fact, specifically, and this will be on slide number 13, as a form of civil disobedience. And that's what I'm going to do. I'm doing it for a lot of different reasons. Here are the steps, and I'll say a little bit more about the motivation in a moment. Motivation background, I want to define immigration fraud, just fraud, like the legal definition of fraud. So some of you, maybe lawyers in the room, we can look at how immigration fraud relates to sort of conventional definitions of fraud. A brief account of an earlier argument that I made with respect to citizenship revocation and whether citizenship status itself can be removed in cases of fraud. Justice constraints, and then finally I will reconceptualize immigration fraud as a form of political resistance. Those are the steps. All right. Now, the motivation actually just is the single most annoying thing that happens in the news. Okay, so I'm preaching to the converted. Hello, converted. But this sort of statement that, you know, all these refugees are engaging in fraud by trying to claim status, or all these would-be refugees, all these asylum seekers are claiming status, but they're fraudulent, right? I know that this is a right-wing trope, but certainly isn't. I'll say in Canada, it's a right-wing trope. American politics is a bit more wackier for me to understand, but at least in Canada, that's the kind of thing that is going on the right. The Conservative Party is constantly trying to, the right-wing party is constantly trying to say, look, we need to combat immigration fraud. And okay, converted. Nobody thinks that what they're doing is fraud. We would say these are sort of the claims that are made. These people aren't real refugees, right? They've gained entry illegally. They're not real refugees in the sense that they don't meet the definition listed in the 1951 Geneva Convention. They're not persecuted because they're on the basis of a social group. They're just poor, right? That's the sort of that claim. The other claim is that they have gained entry illegally. And obviously we've heard Ayten talk about this, David talk about this, right? If they were real refugees, they would follow the law and gain access in the way, because the law has been constructed to allow real refugees to gain entry in a legal way. Or even, maybe more controversially, but not to the converted, that even if your claim is denied, you haven't engaged in fraud, because many people might just not meet the definition, but we're all entitled as a matter of international law to make a claim and to have that claim fairly adjudicated. And so even if after adjudication your claim is denied, you still haven't engaged in fraud. And it's this public debate. It's just like 10 years ago, I was invited by an organization in the city of Ottawa, which, by the way, is spelled O-T-T-A-W-A. And if you don't know why I said that, you could look at the poster outside. To talk to faith leaders about why Ottawa should be a sanctuary city. And faith leaders are often involved in these kinds of sanctuary things in the United States. This is a more popular, sort of a more historical sort of connection. And my job was, just as a moral philosopher, we're going to try to make Ottawa a sanctuary city. We did not. But one of the things we were going to do was try to say leaders of churches and synagogues and mosques and temples to try to persuade their people that we ought to adopt sort of a sanctuary attitude towards people who had gained irregular entry. And my job just was to give people answers to the question that they were going to ask. Aren't people who are here, who are giving sanctuary, aren't they here illegally? Aren't they fraudulent? Aren't they bad? Isn't this a moral hazard? Like if we protect these people, we're going to have to protect everybody. And that was my job. I was just supposed to come in and say, that's a bad argument, that's a bad argument, that's a bad argument. And I feel similarly here, right? Which is to say that what I think I'm doing in this project, at least the beginning of it, is just to say, when we, the converted, talk to the unconverted, is that we need to have ways to explain to them that what people are doing is legally fraud, but as Ayten has just explained, the law constructs these things. That doesn't make what the choices that people are making in the face of these laws are not necessarily morally wrong. So at least morally, we have reason to think we should think seriously about what people are doing in these kinds of cases. Okay, so here's some examples. I'm not going to talk about all of them. Maybe I am going to talk about all of them very briefly. First one, there's a big case just this year. International students from India were discovered to have come to India using what they believed to be fully accurate documents, but it turns out that the immigration consultants that they had been using had fraudulently created letters of acceptances from universities. And so university students, Indian students coming to Canada for study, came to Canada and then got an email saying, oh, your offer has been rescinded. But they were already in Canada on a student visa. And the vast majority of them were like, alrighty, well, here we are. I'm going to do something else, right? And so they were then discovered. They got jobs. They had like legitimate visas to be in Canada, so they got jobs. They rented apartments, and they've been in Canada for several years. They were discovered to have come into Canada. Did they engage in fraud? It's not clear. I mean, morally, obviously, they haven't. What have they actually done? It's not clear. A second case, This is a case which is closer to my heart because in Ottawa, I work with queer refugees and asylum seekers from around the world. But in this case, two lawyers were advising folks from Russia to claim status in the United States as queer, because it's quite, those applications are quite likely to be successful. And so they were teaching people how to act gay. Just we can discuss what that means over dinner. But, you know, like, anyway, teaching people how to act gay and how to answer questions so that you would appear to Western asylum investigators to be gay, to meet all the stereotypes that people have of what it is to be a queer person. Okay, that's a second type of case. And a third type of case is, this is a Canadian example, but this happens elsewhere, which is that people have national identity documents that just won't allow them to gain entry into any country. And so they create fraudulent documents that will allow them to gain entry into any country. And so I think for the converted, these all look like totally reasonable actions that you might take. Unclear about whether or not people from Russia should fake being queer in order to gain access to Canada. But actually, I think, you know, there's a whole cluster of people from Russia who really do deserve safety and security. And so if their truly only way to gain security is to pretend to be gay, it's like not obvious that they're doing something morally wrong. I'm actually prepared to defend that. Okay, so here's fraud. Fraud is the intentional deceit of others to get others to give up something of value to them, to which they are entitled and you are not. So if you're a fraudster, you're intentionally deceiving someone with the purpose of getting something from them that they are entitled to and you are not. You for personal gain, something that you want that's valuable. And usually by claiming things, qualities, accomplishments, background facts that aren't true, right? You're engaging in fraud if you create a CV with job description or a university degree that you don't have. I'm trying to convince Micah to give me a job. I claim a degree from Harvard, which I don't have, a PhD in philosophy, so I look very, very smart. And he gives me, you know, he's got a very valuable job to give. And then I go ahead and get it based on the provision of fraudulent claims, something like that. That's fraud. All right, here's immigration fraud. It's intentional deceit of other states to get those states to offer entrance, residence, or citizenship for the purposes of gaining safety, economic benefit, family reunification. Those are typically the three reasons why somebody wants entry to a state. That's not the only ones, but I think they cover them. Generally by claiming things, qualities, accomplishments, background facts that aren't true. As a matter of immigration law, if there's lawyers in the room, this is typically just called misrepresentation, but just informationally, mostly I'm just signaling to you that I know that piece of law. But anyway, what my argument or the claim about political resistance will turn on is the definitions of 3 and 4. What it means to say that something, so if you just go back one moment, go back, right? Things of value to them for personal gain. You're getting, so the thing of value in the case of immigration fraud is access to safety, economic benefit, and family reunification. That's the thing of value. And you're trying to get states to offer them, right? The thing of value for your own story. Let me get that exactly right. You're trying to get the thing of value, which is entrance or citizenship, legal residence, and you're trying to do that for your own personal gain, which is safety, family reunification, or economic benefit. So just to the extent that it is possible at this late moment, hold that in your mind. All right. Earlier in 2020, during the pandemic, I sat alone and sadly and wrote an article. We were all alone and we were all sad. Well, I don't know, maybe you weren't, but I was alone and sad. And I wrote an article about revocation of citizenship, something which I think is deeply, deeply wrong. I believe firmly, I can defend this if you would like, that once you have citizenship status in a country, that's yours to keep forever and ever and ever. And every time I said that, I've written about it in a million places, and everybody always says, same question, but what about if you got it fraudulently? Like Nazis in the United States, always. Everybody always, it's like, you know, there's that joke about, you know, who's the first person to mention the Nazis? Like, okay, here, like the Nazis, okay. I am opposed to Nazis. Just so we're clear, firmly opposed. And so so we're totally clear. When this clip goes viral, that's what I wanted to say. I am fully and completely opposed. Okay, so I had to rethink what I was saying, because if I had this sort of absolute view that citizenship should never be revoked, what should we do? I argued that actually there's certain kinds of cases where fraud might actually be a legitimate reason to rescind the citizenship that had been given. And I said in that particular instance, if the rescinding of citizenship would not generate statelessness, if it met a certain proportionality assessment, which is to say, if not significant harm would not be generated, for example, to children who had been born to the person who had been gained citizenship fraudulently, certain types of family, separation in the case of young children in particular, and that there had to be a statute of limitations, just like every other minor crime in most countries, that after 5 years, 10 years, we can have a conversation about what that time should be. Citizenship was yours to keep if the fraud wasn't discovered. So I'm gonna this left an exception for Nazis and other genocidaires, individuals who had committed crimes in the past that, if they had come to light, would not even have allowed those people to gain legal entry. I claimed those people could then have their citizenship revoked. I want to say that so by analogy, or just I would just want to be consistent, it's not even an analogy, that in the cases of immigration fraud, if somebody can commit immigration fraud to gain entry, and we later discover that they have been engaged in crimes that would not have allowed them to gain entry, and they're serious crimes, we can have a whole discussion about what those should be. Then those people have committed immigration fraud, which is morally problematic. Okay, so I got 8 minutes, 7.5 actually, an extra 30 seconds if you don't include the math joke. So look, fraud, I think, so in the longer version of this, here's the short version, but in the longer version, I say the same thing, just with more words. Fraud, it can only, if we're gonna think that fraud is morally problematic, it has to be in the first case where background conditions are just, right? It assumes that sort of the distribution of goods and benefits is already fairly done. But see the two previous talks, they've already persuasively made the case that the global migration system is broadly unjust for all kinds of reasons, but for some of the ones that have just been discussed, states actively adopt and protect policies that sustain immigration injustice, that make it impossible for people who are in situations of massive insecurity to gain access to the security to which they're entitled. The pursuing of these unjust policies generates the conditions. So it's like, I just want to say that Ayten and I didn't coordinate our talks. I didn't copy her. I could not have written this in the 15 minutes between her talk and mine, okay? So just so we're clear, I came up with this on my own. Okay, so the pursuit of these policies create the conditions which motivate the behaviors, right, that are known as fraud. This is exactly the lawful unlawfulness that she talked about. And because of all of the above, states are just not as entitled to border control as they would be otherwise. So I'm actually, contrary to some of the open border advocates, at least in the, I don't know if there's any in the room, there's some in the Zoom. I do believe that there are conditions under which state control of borders can be justified, but it certainly has to meet at least some minimal justice constraints. We can have a conversation about what those are if you care about them, but at least, at the very least, I think we can agree that the current conditions are not it. And so, since the global migration regime is unjust, states do not have full entitlement to control their border. And it's specifically, remember I asked you to keep this in your head from the earlier slides, conditions 3 and 4 with respect to what immigration fraud is. It's failure specifically on condition 3 of the definition of immigration fraud to get people to give up things of value to them, to which they are entitled, but the fraudster is not. But if you agree, because Ayten persuaded you that the immigration system is not just, then states don't have the right to control their borders, and they don't have the full right to make decisions about who can gain entry and who can't, using the criteria that they have, which allows them to identify specific types of behaviors as fraud. Okay, so states aren't as entitled as they would be under conditions of justice to give out safety, security, in the form of residence or entry. And second, the thing of value is a severe mismatch, right? This is an argument which has been made by many other people. I'll cite Michael Blake here just because he's an all-around nice guy, right? Which is to say that actually, it's not like when somebody's safety is on the line, access to a state is what they need. But welcoming another person into a state, especially like the United States or Canada, is actually not that big a deal, right? We can both of our countries can usually take an extra few people. Okay. We obviously can't take in the whole world. There's problems, but my favorite example, which is Germany, quite easily, there's growing pains, I know there's growing pains, let in 1 million Syrians over a very short period of time, and the country is still functional. So others of us can also do the same kind of thing, which is to say that the thing that states have to give out is extremely valuable for the individual migrant and much less valuable to protect for the state. As a result, I think, immigration fraud is not morally wrong. Why should we think of it as a form of political resistance? This is my 12th slide. So there's only, if you were paying attention, you know there's only one more after this. Not all forms of law violation are political resistance, right? When people jaywalk, they're not engaging in political resistance. They're not, you are? All right, outside of Boston, I accept the modification. Many people outside of Boston are not engaging any type of political resistance when they cross the, you're like agreeing with him? Is that?
Not from here, so.
Like you're engaging, so when you jaywalk, you're engaging in political resistance. Yeah. Okay, we're gonna discuss this. I'm skeptical. Can I think of a better example? A different example. Okay, most people who choose not to pay their subway fare are not engaging in political resistance. They're just trying to save $2.40, which is how much I learned it takes to go on the T today. Okay, so they're just violating the law, right? Like they're definitely violating it, but they're not engaging in any type of resistance. They're not like a part of a movement. Immigration law violations are not like this. That's what I think. Rather, we have reasons to think that they should be interpreted as a form of political resistance taken by those who are most disadvantaged by the current global migration system. Here's why. So I is not fully a political philosopher crowd, but I can defend this using Rawls's theory of justice and his account of civil disobedience, if you'd like that. But in general, I think here are these reasons why we should consider these fraudulent actions as a form of organized political resistance. They're unlawful, they're intentional, just like every case of fraud. They highlight the injustice of immigration laws, but they're not always the same ones that are broken, right? So like if we talk about, I'm running out of time, but if we talk about civil disobedience, the picture of civil disobedience is of people who break this law to shed light on that law. In Canada, Indigenous protesters frequently violate traffic laws by having protests which block traffic. It's not because they have an objection to traffic laws. It's because they have an objection to ongoing settler colonialism, right? So they're engaging in civil disobedience to highlight something else. I think the same thing is going on when people could engage in immigration fraud. It's closer, but they're engaging in the process of trying to get access, and in so doing, they highlight for us the injustice of the regime as a whole. How do we know this? Because in so many cases, not in the pushbacks that Ayten was describing, but in many cases, we actually adjudicate these, right? People will go to court and say, or they'll have hearings. In Canada, we have the Immigration and Refugee Board, the IRB, and they will adjudicate these cases where people have come in fraudulently, and people will say, yeah, fraud, sure, fraud. But like, if you send me back to this region of Nigeria, I'm going to be persecuted because I'm a woman. I'm going to be persecuted because I'm a Christian. I'm going to be persecuted because I'm queer. And so we learn of other reasons why, even though they have violated the sort of specific law, that they should be entitled to stay. And so in sum, I think we should think about this action as a form of political resistance, and possibly, although I didn't put this in the slide because I didn't think I could defend it, possibly as an organized form of political resistance. Thank you.
Questions from the audience here or on the Zoom webinar? Is this working?
Okay, sorry, I'm slightly sweating. That's gross, but sorry. Try not to say that. Does that mean? Oh yes. Whoa. Okay.
Thanks so much. So let's go back to leave it on the question again. The first question. I substantially totally agree with you, I think, and also with the civil disobedience part. But I do think that it's hard to do an arousing conception for a variety of reasons. I mean, one is that laws one nationally organized community, one citizen engaging in this act, others, why they should rethink how they organize the community. So that's the first kind of agent of disobedience thing, which I think requires us to go beyond not just Gaussian, but really, I think, most liberal conceptual disobedience. And the other one is the kind of conventionality criterion. I think this was off, sorry. So the first part of the question was, there's the kind of assumption in Rawls that it's citizens engaging in civil disobedience. That's the meaning of the civil, even for him. But the second part is the intentionality criterion. So of course, there are some migrants and refugees who engage in fraudulent border crossing or irregular border crossing with the intention of highlighting the injustice of the system, maybe even challenging or transforming it. But a lot of people, for entirely, I think, legitimate reasons that don't necessarily affect negatively the moral assessment of what they're doing, do so just in order to get in, right? And maybe in conversation you could convince them that there's this additional layer and that you should really describe it in that way. But many of them don't, and I'm not sure if that should be a requirement of thinking of it as legitimate resistance.
Yeah, I actually probably think you're right. I'm deliberately what's the word, like papering over the use of what it means to say that something's intentional, because they're obviously intentionally engaging in fraud to gain entry, and in Rawls's account of what it means to be intentional, that you're intentionally trying to draw attention to some sort of other form of injustice, at least as an account of civil disobedience. So I think that's probably right. I could just stop there. So would I say more about defending the use? I guess the thing that I would add to this as you pack up is that I might be able to make the claim that there's sort of an after the fact intentionality associated with it, because when you look at the hearings, when people's fraud is discovered and they go to hearings to try to make the case, usually what they say, I mean, obviously they're guided by lawyers, but usually what they don't just say, like, I'm so sad and things are so bad for me. They usually say the system is rigged against us. We need people to engage in a sort of a political, like in making public that the system is constructed in such a way that people who are like me cannot gain entry, and we are forced into this circumstance. And so I guess the question is, can I make that persuasive? That there's sort of a reflective, unreflective equilibrium, sorry, bad joke, on reflection, that the intentionality can come around to the right thing. I mean, I think that I can do this mostly because I think that any reviewer of any article is going to be so sympathetic that they're going to be like, oh yeah, that's so good. They just let it through. We're all, this is what happens because all philosophers agree on the badness of the situation we're in. But that's the sort of the strategy that I took in the paper, is to say we can do that. So on Raw, are you like, is this like you want to come in on this question?
I do, but I can wait till you.
Are you going to help me?
No.
Okay, then just wait your turn.
Maybe.
Maybe. Do you want to come and, okay. So that's, yes, right. So who's the agent? So yes, in order to make this a fully Rawlsian story, I don't actually want to do that. I was harassed into doing that. This is a longer story. I could tell you over dinner, into sort of making that kind of claim that all of the ways that I think of political resistance are in fact Rawlsian in form with respect to sanctuary, which I'm not super happy about. But I guess what I want to do overall is to highlight that these 4 clusters of resistance are all sort of doing something purposefully to disrupt the injustice, and that we should treat them together because they're engaging in a sort of a public demonstration of intentional rule violation with the purpose of personal gain, but also it's in the direction of global change. So I don't know. I might go with a global civil disobedience sort of strategy, or I just might not. I just have to say Rawls, otherwise political philosophers don't take me seriously. Anyway, that's what I've got.
Huge room was wonderful.
Since I don't know you, could you say your name?
My name is Jeff Rubin. I'm in the history department here
Okay.
at the
Hi.
U and have been part of the seminar
Thanks.
at times. Hello,
Hi.
thank you. I have been critically engaged with and wondering about the notion of resistance, at least since the 90s, when Weapons of the Weak by Jim Scott and Spirits of Resistance by Iowa On came on the scene. So my question, simply put, is why you want to use the word. Because a lot is implied by the word that isn't always happening on the ground. There's a lot of ethnographic fleshing out in regards to intention and impact. So I wonder why you wouldn't want to just say, these are the ways in which people act in this situation. These are the things they're thinking when they do it, and these are the effects that it has. And maybe you might then see patterns and similarities that you want to come up with a word for, but I'm not sure why resistance is the word you want to use.
Yeah, I don't feel strongly. I'm happy to concede your point. I mean, why resistance? I don't really have a great answer to that question. But I definitely want a word. So why resistance? Because I want to put these kinds of actions taken by these discrete non-state actors. In fact, actually, I actually want to say that state actors do it too, but only in particular moments. So I'll say something about that. But basically to say that these sort of clusters of actors, NGOs, individual humanitarian actors, migrants, are all doing something that is to resist. But I'm happy to just like now just put that in like light font, right? So it's possible to be replaced. But they're doing the same thing, all in the direction service of undermining an unjust global migration system. So that's the reason why I've chosen it. But I'm not wedded. If you have other words that are like obvious to you that you think might be useful, I'd be happy to take them. Others are welcome to contribute to this project as well. So I guess that, yeah, sure. Yes, you're right. You could be right. I'm willing to consider the possibility that you're right. Oh no, can I say one other thing about states? I actually think, like, so this project actually starts with an analysis of moments where states themselves engages. So this is why I think that you might be right. That states engage in openness that was unexpected. So the Ukrainians are one example, and everybody always wants to call it racist because it's, they let in the white guys, but not the rest of them. But actually, it's still a moment in which the world says, you can come, right? And Angela Merkel's choice to let in 1 million Syrians is also like a moment in time where she makes the call to let people in, like 1 million. That's a lot of people whose lives, I don't know if they're good in Germany, but they're at least alive, mostly. So there's moments. I mean, the big Canadian example, there's many, which I'm going to bring up at dinner, is that in 1972, the Canadians, in response to Idi Amin, actually went directly to Uganda and just had plane loads of East Asian Ugandans coming to Canada. They didn't even make the Ugandans leave the country in order to consider them refugees. So there's these moments in history where states make different decisions, so that this goes to your point that maybe it's not resistance, but it goes to the point, like it's like it opens up a space for thinking more positively about the role that states themselves might play in making the world a more open place, which is why I'm less critical of the Ukrainian initiatives than others have been, because if states can do that for Ukrainians, then the barriers to doing this for other groups, even racialized groups, are lower than if states never did it. And I think that's really important. But that suggests you might be right.
Thank you so much, Patti. So I'm going to ask a question, but then before that, maybe I should clarify my comments about Ukrainian refugees, right? So I don't want to say that, that wasn't a nice thing, right? It's, of course, they had a legitimate claim to protection. It's just that people who were fleeing Ukraine, exactly the same condition, yet they are non-Ukrainians, they are citizens of India, Pakistan, students there studying, they faced a very, very different reaction. And legally speaking, temporary protection was not offered to them. It was left to the discretion of individual states to basically assess their claims. So it was really this kind of very double standard in the same case itself, rather than let's say.
I would never disagree
Yeah.
with you. I mean, my space is queer refugees, and the treatment of trans refugees from Ukraine into Poland is I mean, I think the technical term is bonkers, but like again, there is not every community of people in Ukraine were able to get access to this security and safety, but nevertheless, I think it's an interesting moment.
And the question I had relates to both of these questions, actually, more to Robin's question about why use the term civil disobedience, more than the Rosian part, why civil disobedience? My guess is that civil disobedience is not going to work with all of these 4 different kinds of resistance to immigration and justice, right? And particularly, I was thinking of the case of NGOs such as Sea-Watch, where the states are claiming that they are violating laws, state laws. So the framework of civil disobedience, framing this as a civil disobedience, might actually give justification to states' representation of what Sea-Watch is doing as a form of law breaking. Whereas Sea-Watch is saying that, no, actually, it's not us, it's the states who are breaking the laws. They are breaking specifically the maritime law in this context. So there are also other forms of, I guess, resistance or other forms of agency, political claims making, legal claims making, that do not necessarily fit basically this framework of civil disobedience. So I want to hear a little bit more about what drew you to civil disobedience in particular.
That's what you want to hear. Okay. So again, I don't feel okay. I mean, okay. So like Jeff is like, no resistance. You're like, and you and Robin are like, the civil disobedience frame's not going to work. All right. So listen, I'm going to give you my email address. And you could like, so that I could, if I wanted to reconstruct this, talk about agency, weapons of the weak. Agency by rely on some notion of agency. So I'm going to think about that. I'm going to think about that when fewer people are looking at me. But actually, so in every case of civil disobedience, this conflict is the one that happens, right? I mean, isn't it? Isn't that the case that the civilly disobedient says the state is engaging in injustice, and the state says no, you're the ones who is engaging in role violation. And then as political and moral philosophers, what we do is we look at the action that somebody is taking and say, does it meet the criteria of civil disobedience? Do you have a moral claim? Is it publicly made? Does it apply widely? So I don't immediately see, is this you? You're going to explain to me why? You can do. I don't immediately see why Sea-Watch isn't a good case, because what they would say is we are engaging in what justice requires. The state is engaging in rule violation. The state looks back and says, you're not engaging, you're engaging in law violation. This doesn't count as civil disobedience. We have laws. And then they say, no, but it does, because here are the moral reasons we have for acting against the law that you have established. Here's what we're trying to do. Here's the higher moral order. Sure. I don't mind.
So in that particular case, unlike the other cases of civil disobedience, where basically we see civil disobedience engaging in law breaking to test the legitimacy to basically make a statement about the injustice of other laws or even the legal order itself, in these cases, the Sea-Watch case, they are not referring to a higher law. They are not referring to justice. They are not referring to necessarily moral law. They are saying you are violating your own state is the lawbreaker. You see what I mean? We are not breaking any law. Basically, as any vessel in the sea has to provide assistance to a vessel in distress. So when the state, for instance, Coast Guard is not doing that, they are actually violating that international maritime law. So it's not necessarily a higher law. They already signed those treaties. It's part of their law. They are violating their own laws, the laws that they subscribe to in the first place. And that's why, so in that sense, it's not, they don't describe themselves, what they are doing in the interviews they give, in the comments they are making. they don't describe their own action as civil disobedience. They are saying we are not disobeying any law. We are actually obeying
Following
the
the
law,
law.
following
Okay.
the law. It's the state
Okay.
that is disobeying,
Okay,
violating the law.
okay, that's really interesting.
Yeah.
Right, okay, so the accusation in the Sea-Watch and similar cases is that states have laws and they are following them, and by persecuting or prosecuting Sea-Watch, Italy in that case was violating its own laws. Okay, okay.
Similar to the pushback cases too. State is violating the law.
Okay.
Its own laws actually when it does that.
Okay, okay, I really appreciate that, and I'm gonna think about it when you're not looking at me.
David, go ahead and ask your question.
Thanks. So Patti, thanks very much. Just as a quick follow-up to Ayten's, Itamar Mann's book, Humanity at Sea, is the one you need to look at to, check out the maritime stuff, but that was, on my understanding, entirely right. I kind of wonder, I also wondered about the resistance stuff, and about the civil disobedience stuff. So there's a lovely kind of line in Foucault when he says, look, critique is a kind of art of voluntary inservitude, a kind of form of reflexive indocility. And what is going on there is a kind of refusal to be governed like this at this cost. So I kind of want to say two things. One is that maybe kind of it's a refusal rather than resistance that's at stake. And secondly, that seen in that way, just the performative act of refusing is raising a claim about either legitimacy or justice, or possibly both. So why can't you say, look, the performance of that act of fraud, whether it's kind of, intentionally drawing attention to, it is, as it were, regardless of intention, raising a claim. It's making a claim about the laws to which the state wants to say you are subject. And it seems to me that that kind of would get you pretty much everything you want, while allowing you to avoid a criticism that says, oh no, intentionality is missing here, so it's a problem. Okay, because you don't need intentionality, because you don't need, the civil disobedience kind of classic liberal frame. You can just say, no, this is raising a performative claim about injustice, and that's what matters. So that was my thought.
Okay, that's really helpful. I'm tempted to look over to see if this makes Jeff happy. Jeff is smiling, so that's a good sign.
Yes, it takes it in
Okay. I'm gonna
add to that. What about don't over romanticize intent, which is what I hear about on here, or make it a requirement, and don't romanticize effect either, which is different. To what extent, in what way, when is it clearly making a public claim? It's not, I agree that it is, and I agree that it's not intentional, but I'm worried that using the word, because of its historical significance, in what resistance means, using the word over and romanticizes or makes an automatic and perhaps too big claim about intent. That's my worries, and yes, what David said addresses part of that.
Okay. Did you hear that, David? No, it's okay. You can. I don't know.
No. I'm afraid it was too echoey.
No. Okay, so there's here's the short version. Jeff agrees. He said that in a longer way that was helpful to me. Are you also good? Are you gonna? Yeah. Yeah. I see your face here, but I don't know your name.
Carrie.
Hi, Carrie.
Yes. Thanks so much
You're
for
welcome.
this. It's provocative and interesting, obviously. So my concern added on to what David and Jeff are saying, absolutely the performative effect of the claim where civil disobedience seems to completely fall away is the liberal assumption of a kind of solidarity, a community working for change. And we actually know historically that people who have gotten asylum or have immigrated to a place are not actually about changing the laws or making them more fair. Often there's a sort of, well, I did it legally and they're not, or my claim was justified. And so there I see, are they really asking for the laws to be changed for everyone to get to this morally fair context and background? Or like absolutely legitimately trying to save their lives or reunify with families? Yes.
Okay, no, this is good. This is good. Okay, okay. Thank you. Thank you, Carrie and team. So yes, okay. So I don't actually, the language of performativity is not one that I'm familiar with. So so I'm not sure about, so I'll have to read about that, what it means to say that, but yes, right, okay. So people are taking actions which, even if they don't intend it, this is the sort of the collective where we come to collectively, even if they don't intend for those actions to signal this, actually are making a claim of justice of a certain kind. And we can read the actions as making a claim about, in particular, injustice, even if they don't have intentionality. That's Jeff saying, don't romanticize intentionality. Okay, good, I'm happy. That seems, I will take that home as something to think about. Can we, so I'm interested in this, like, can we think of these set of actors as a community? And Carrie's question is not just, can we think of them as a community, but what do we do about the fact that immigrants come, and so many immigrants, in particular refugees, but a whole wide swath of them come, and then they say, they have this reaction, like, I followed the rules, they have to follow the rules too. And they don't turn out to be more necessarily, in every case, more open to justice claims or migration claims or unfairness claims. So, all right. So I guess I do want to think of these non-state actors as sort of acting collectively in the direction of a shared objective. So, so I hear from your question that I didn't make that persuasive. I'm happy to think about how to make that more persuasive. But I think that I do want to think about that, because it's like, you know, I don't know, you go around in the border, like the externalization of border migration space. Oh, the time is up. Okay. But Micah's, okay, online people, Micah's not stopping me. This is Micah's fault. Oh, we do? Oh yeah. All right, whatever. I'm gonna go on forever until somebody stops me. I love talking. So, okay, so, but I think I do want to say that they're a community of people, and I want to do it because some of them do think they're in a community. I think that's really important, and also to construct a sense of community. And then this is what I was saying, but like it's like the border externalization like space, this is like the most depressing place to be, right? Like, I mean, there's like nothing worse than your research, Ayten. Like, I mean, you know, like pushbacks, people are dying, they're dying in the Mediterranean, like they just like it's like, oh, it's terrible. Like I mean, you know, I refer to the work that I do with queer refugees. Pakistan just closed its borders. Like, it's just like, it's like not letting people out. It's like, you want to get out? Sorry, we're keeping you in. Hates the Afghans, is discriminating against them, prosecuting them, persecuting them, everything. But it's like, we're like, great, send us to your gay Afghans. We'll take them. And they're like, no. Okay, this is dumb. It's like, it's depressing. It's one big field of depressingness. And so, like, I guess part of what I want to do is like write a hopeful project, a hopeful book that says, actually, there are these pockets of people who are not accepting. They are refusing. They are, by their actions, refusing to accept an unjust space. And so, I mean, so then I will have to look more at the sort of the solidarity literature to sort of make the claim that these sort of disparate communities and these disparate spaces meet that. This is independent of whether I want to say they're engaged in civil disobedience. This, I hear from this audience that nobody likes that frame, so noted, it's been noted. But yeah, so that's what I want to do. I want to write a hopeful book so that those of us who are like, we have to do something, we can do something, don't feel alone. it's a type of therapy.
I was going to ask a last question, but I think it's appropriate to end on the note of hope. So I just want to thank everyone who participated, all the presenters for their wonderful talks, everyone who participated both in person and online on the webinar. Thank you, and we hope you'll join us next month for our next seminar, which will be on October 23rd and is on funding externalization and its economic impacts. Thank you.
Thank you. Thanks so much.
Thank you, Micah.
Thanks, David.
Do these chat people say anything I want to know about?
I don't know. I think I can save the chat if you don't.
No, I don't think so.
I think I can.
People.
Yeah.
No.
They actually really weren't.
Okay, no, they were not.